Hello everyone, my name is Erni, NPM 1951021, 3IHMA. I am a law student at UIB, University of International Batam, and I'm going to do a presentation about private international law. So first, we have to know what is private international law. Private international law is the choice of the law to apply when there are conflicts in the domestic law of different countries related to private transactions. Private international law deals with a variety of topics such as international contract, family matters, recognition of judgment, child adoption, real property and intellectual property, and etc. So, private international law apply when there's one country and then another country make a private transaction or international transaction, and then there are conflict arise. That's where private international law apply. The example like maybe when a citizen at one country marriage with a citizen B country, where the marriage shall have administered if they're divorced under A country, it is valid under B country law. It is like that. And then conflict of law. We usually hear conflict of law. Are conflict of law different with private international law? The answer is no. The difference is just conflict of law is adopted by common law states of a country such as United Kingdom, United States, Canada, Australia, while private international law is adopted by civil law country like Indonesia, Netherlands, and etc. So why we need private international law? Because private international law allows business and individuals to assess the risk of international transaction and relationship and to take steps to manage those risks where possible. So when one country and then another country make international transaction, um, it can make a problem. Why? Because the law of this country is different. Country A law is different with B country law. In the world, there are no 100% same law. So this is where we need private international law to solve this problem. So next is the aspect of private international law. The first one is jurisdiction of forum. Jurisdiction of forum is which the forum operates. So what the forum that we use. The second one is the competing state law. It means what law we use. If there are problem, if A country and B country have a problem, let's we use A country law or B country law. And then the third one is the enforcement of foreign judgment. It is like when there are a problem with A country and B country transaction, if we solve the problem with A country law, it is valid under B country law. The example like if Budi, a Singapore citizen, and Rini, Indonesian citizen, divorced in Singapore, is their divorce acceptable in Indonesian? It's like that. So next is choice of law. Choice of law is the law chosen by forum court from relevant legal system when it judges an international or interjurisdiction case. Court is faced with a choice of law is to have two-stage process. The first one is the court will apply the law of the forum or lex fori to all procedural matters, including self-evidently the choice of law views. And then the second one, the court counts the factor that connects or link the legal issue to the law of potential relevant state and applies the law that have the greatest connection. So the first one, the court will apply the law of the forum, lex query. And then the second one, the court will count the factor that connect or link the legal issue. Um, the court will make a characterization and then find the connecting factor between this country. And then forum section clause, an international organization that focus on the field of so forum section clause, there are three types of clause. The first one is the reference might be to a particular court in jurisdiction agreed upon by parties. The second one is the clause may refer to a specific kind of dispute resolution process such as mediation, arbitration. The third one, the clause might refer to both, requiring a specific process to be carried out in a specific location. So when we decide the forum of the lex query, there are three types of the clause. The first one is when the requirement may be particular court in jurisdiction agreed upon by parties. So the party agreed to use what forum, what law. So the second one, the clause may refer to specific kind of dispute, such as mediation or arbitration. And this means like when they make a contract, they make a transaction, they already decide where the arbitration gonna take place, where the mediation gonna take place, what form will they use. The third one is the clause may refer to both, so they use both, require a specific process in the specific location. So next is the status of the foreign law. When the court is to apply a foreign law, it must be proved by a foreign law expert. It cannot merely be pleaded, as the court has no expertise in the law of foreign country nor in how they might be applied in a foreign court. Such foreign law may be considered no more than evidence rather than the law because of the issue of the sovereignty. So, when a court applies the foreign law, it must be proved by foreign law expert because if the um, the law they use that cannot be applied in the foreign court or the foreign law, it is no use. It may be concerned no more than evidence rather than law because of the issue of sovereignty. So next is harmonization. Like I said before, there are the country has different laws, so we have to harmonization. To apply one national legal system as against another may never be entirely satisfactory approach. The party interests may always be better protected by applying a law consistent with international reality in mind. So there are the Hague Conference on Private International Law. It is an international organization that focuses on the field of international private law, which aims to manage several legal conventions, legal protocol, and international legal instruments. So the legal convention, legal protocol, and international legal instrument is to make a harmonization between countries because country has the country has no 100% same law. So this is the one of the use of the conference on private international is to make a harmonization. Next is characterization. The court must analyze the case as pleaded and allocate each component to its appropriate legal classification, each of which will have one or more choice of law rule attached to it. So, when there are cases, the court have to allocate each component to appropriate legal classification. Like this, I already the court analyzes the case as stated and allocated its component to appropriate legal classification, and the classification is connecting factor. Like lex domicile is where their domicile, lex patria is what is their nationality, lex situs law of the place where their property is situated, lex luci contractus law of the place where the contract is made, lex loci actus the law of the place where the contract was signed, lex loci delicti commissi the law of the place where the delict was committed, lex loci celebrationis law of the place where the marriage was celebrated, lex causae law of the cause, lex fori forum selection clause, lex loci arbitri law of the place where the arbitration is to take place, lex loci damni the law of the place where the injury occurs. Next is incidental question. An incidental question is the legal issue that arises in connection with major cause of the action in a lawsuit. So when we find the characterization and then connecting factor, we may have incidental question. Um, the example of incidental question is like um, when we apply with lex domicile, where they domicile, if A has Indonesian nationality and then he domiciled in Singapore and then they use Singapore law, it is valid under Indonesian law based on their nationality because their nationality is a nation. It's like that incidental question. Or if the other example, like maybe if Mr. A and Mr. B divorce under Singapore law when they celebrate the marriage in Indonesian and then they have kids in Singapore and then they're gonna divorce and the custody of the child goes to the father based on Singapore law, but it is valid under Indonesian law. And if Mr. A and Mrs. B have maybe some property, this gonna to be under Singapore law or Indonesian law. It's like that. The next is the procedure for conflict cases. First, the court must first decide whether it has jurisdiction to hear the case. Second is characterization. The court must analyze the case as pleaded and allocate each component to its appropriate legal classification, each of which will have one or more choice of the law rules attached to it. Third one is the court will then apply the choice of law rules in a limited number of cases, usually involving familiar law. Issue and incidental question can arise, which will complete this process. So first, the court will decide where the judge, whether it has jurisdiction to hear the case. After that, the court will characterization it with connecting factor, and then the court will apply the choice of law rules, and then some incidental question can arise. So it is the procedure. Next is forum non-convenience, whereby a court acknowledges that another forum or court is more appropriate and send the case to such a forum. So when a court accept or receive a case, then study it, and then the court realize and acknowledge that this court is not appropriate to handle this case. So the court will send the case to forum non-convenience. And after forum forum non-convenience is a legal doctrine used by common law courts to determine issues of jurisdiction, particularly with regard to foreign judgment and foreign court proceedings. The underlying principles, such as basing respect given to foreign court on reciprocal respect or comity, also apply in civil law system. List alibi pendens. A concern often raised in the application of the doctrine is the forum shopping, or picking a court merely to gain advantage in the proceeding. So, forum non-convenience is after forum convenience, they are renvoy usually. Renvoy is from parents, meaning send back. Is a subset of the choice of law rules and it is potential to be applied wherever a foreign court is directed or considered the law of another side. So after they decide the forum of non-convenience, the court will send back to another set that are appropriate to handle the case. They're gonna rent for it, send back. It means send back. So next is forum shopping. Forum shopping is the informal name given to the practice adopted by some plaintiffs to get their legal case heard in the court thought most likely to provide improbable judgment, or by some defendant who seek to have case moved to different court. So forum shopping is is when Mr. A search when one person search a forum that have the favorable judgment for themselves, and to avoid renvoy or forum non-convenience, we have to do forum shopping first. So it will not waste our time to send the case to wrong court. Next is list alibi pendens. List alibi pendens is dispute always pending. Applies both in municipal, public international law, and private international law. List alibi pendens is a plea that the dispute is continuing in another court. It may allow the action in which is pled to be suspended, while the other action is concluded. So list alibi pendant is where when the case that already been played at another court and then been played at one court, it is pending, cannot be done. Why? Because the rule of list alibi pendant first was res judicata provide that once a case has been determined, it produces a judgment either inter partes or in rem, depending on the subject matters of the dispute, and neither party can recommence proceeding on the same set of the fact in another court. If this rule were not in place, litigation may never come to end. The second one is proceeding on the same fact cannot be commenced in the second court if the list alibi pending. Example action is already pending in another court. So when a case already applied in one court, it cannot be applied in another court at the same time. The another court will make a list already pending. It means pending, already pending in another court. So next, I'm gonna give cases to see. Start from the cases. This is the case, example case. So Mr. Blue, who has Indonesian nationality, is married to Miss Red, who has Zimbabwe nationality. The wedding took place in Philippines, and now they both domicile in Malaysia. After Mr. Blue got married, he made a lease agreement with Mr. Black, who has Singapore nationality, and then residence in Thailand, regarding his property in Korea for 3 years. The agreement was made in Korea. Mr. Black then made the property into a restaurant. In the first year of opening, an accident happened. The restaurant was on fire and is unrepairable. For that reason, Mr. Blue demands compensation for the damage of his property. According to their agreement, this case will be solved in the Thailand court with Thailand law. The Thailand court accepts the case, but cannot solve it because the agreement and the restaurant were made and located in Korea. Since the Thailand court cannot solve the case, they decide to refer this case to the Korean court. So first we gonna make a characterization. This is Mr. Blue, and then this is Miss Red. Mr. Blue, who has expatriate mean nationality, Indonesian. Miss Red is Zimbabwe, and then they domicile in Malaysia. And while Mr. Black has Singapore nationality and then domicile in Thailand. Mr. Blue and Miss Red got married. Lex was his celebrationist, where the marriage was celebrated in Filipina. And then Mr. Blue and Mr. Black make a lease agreement to rent a house for a restaurant. Lexitus in Korean, it's mean the object in Korean, the restaurant in Korean. Lex was his contractors in Korean. It mean the contract in Korean. Lex loci actus in Korean. Lex loci delicti commis in Korean. Lex loci solution in Korean. Lex loci delicti damni in Korean. Lex fori or the forum section clause in Thailand. And then Lex cause, choice of law cause in Thailand. And then after Renpoi, the Lex fori is Korean, and the Lex cause after Renpoi is Korean. So this is the characterization using connecting factor. So because the connecting factor is greatest in Korean, the court decide to renvoy this case to Korean court. Before they renvoy it, they decide this case is forum non-convenience, and then they renvoy it. Okay, that is the case. So that is my presentation. Sorry if I was wrong, and thank you for your attention.